Alrighty, so my name is Pierce Brown, and I did the topic of gender discrimination under the Civil Rights Act for this presentation, and basically I did it because I have done research on this before. However, this time around, I just wanted to see if I could go ahead and expand on it and maybe just make a better presentation altogether. So, to provide some background for it, in 1964, Congress passed the Civil Rights Act, and basically it was passed to prohibit discrimination of protected classes. And some examples of these classes include race, color, religion, sex, or national origin. Furthermore, it prohibits discrimination on the basis of sex and race in hiring, firing, and promotion practices. And then we see here that the Civil Rights Act of 1964 is recognized as Public Law 88-352 by Congress, otherwise seen as 78 Statute 241. So next we're going to discuss some Civil Rights Act counterparts. First we see Title VII, and this is Title VII of the Civil Rights Act of 1964, and this prohibits employment discrimination based on race, color, religion, sex, and national origin. This law applies to all employers with 15 or more employees. Next, we see the Americans with Disabilities Act, or the ADA of 1990, and the ADA prohibits employment discrimination against individuals with disabilities and requires employers to provide reasonable accommodations to the employees with disabilities. However, the accommodation doesn't need to be provided if the case of doing so would provide undue hardship to the employer. This law also applies to all employers with 15 or more employees. Next up, we see the Age Discrimination in Employment Act of 67, and the ADEA prohibits employment discrimination against individuals who are 40 years of age or older. That's important to note the 40 and older part, because in my industry you can be discriminated against for being under 21 and therefore not allowed to work in storefronts. This also applies to employers with 20 or more employees. Next, we see the Equal Pay Act, or the EPA, and this requires that men and women be paid the same for performing substantially equal work in the same workplace. This law applies to all employers, regardless of size. Next, we see a case that kind of reinforces things, and this is Weeks v. Southern Bell, which fought against restrictive labor laws and opened many previously male-only jobs to women. And lastly, but not least, here we see the Pregnancy Discrimination Act, which is the PDA, and that prohibits employment discrimination based on pregnancy, childbirth, or related medical conditions. This law applies to employers with 15 or more employees. So next up we're gonna discuss the EEOC, which is the Equal Employment Opportunity Commission, which enforces the federal laws prohibiting employment discrimination. So on top of prohibiting employment discrimination and employment based on topics already discussed in this presentation, the EEOC also takes into consideration pregnancy, sexual orientation, and gender identity when fielding complaints. Next, we see that employers with over 15 employees are prohibited from discriminating in their employment decisions. So examples of employment decisions can include processes such as job application, hiring, firing, promoting, training, wage earning, or really any other terms, privileges, or conditions of employment. So next we're going to discuss compliance in action. And as found in prior research, the EEOC has a focus of systemic enforcement. And the definition of that is going to be a pattern or practice, policy, and or class cases where the systemic discrimination has a broad impact on an industry, profession, company, or geographic location. So the case is essentially very broad spanning. And some other enforcement measures include federal laws, which are passed by Congress and signed by the President, regulations, which are voted upon by the Commission after the public has kind of had a formal opportunity to offer comments to the EOC. Then we see sub-regulatory guidance, which is express official agency policy and explains how the laws and regulations apply to workplace situations. Next, we see commission decisions, which concern of specific charge of discrimination, where the commission votes to express official agency policy to be applied in similar cases, so essentially providing precedent for EEOC cases. And then we see commission opinion letters, which are statements essentially approved by the vote of the commission and represent the official position of the EEOC. So next we're going to go ahead and get into a case of Ledbetter versus Goodyear Tire and Rubber Company, where the Civil Rights Act was violated or claimed to have been violated. And basically, Lily Ledbetter worked for Goodyear Tire and Rubber Co. for almost 20 years and essentially discovered that she was being paid significantly less than her male counterparts, who were basically just performing the same job. And Ledbetter ended up filing a lawsuit alleging that Goodyear had violated Title VII of the Civil Rights Act by paying her less than those not her gender. And the Supreme Court ended up ruling against Ledbetter, unfortunately, because she had waited too long to file her claim, and that she could basically only sue for the pay discrimination that had occurred within the 180 days of the initial decision. This ruling essentially prompted Congress to pass the Lilly Ledbetter Fair Pay Act of 2009, which expanded the time frame for filing pay discrimination claims. And we can kind of see how this case shows potential for the EPA as a counterpart, based on the fact that this is a situation arising off of pay concerns. Next, we're going to go ahead and discuss Johnson Controls versus UAW. And in this situation, Johnson Controls had a policy that prohibited women from working in jobs that had exposed them to lead because the company simply believed that lead exposure could harm fetal development. A group of women were excluded from these jobs and ended up suing Johnson Controls, alleging that the company's policy violated the Civil Rights Act by discriminating against women. The Supreme Court ended up actually ruling in favor of the women, stating that the policy discriminated against women by excluding them from jobs that they were qualified to perform, and that the Johnson Controls had not shown that the exclusion of women was a business necessity. This case set an important precedent for employers that shows that they cannot exclude individuals from certain jobs based on gender unless that they can prove that that is a bona fide occupational qualification. Now, this shows also the potential for the PDA as a counterpart, because this shows you can't exclude someone from work that you think might impact them negatively. You can only exclude people based on qualifications of effectiveness. And then going forward, I go ahead and look at this and kind of apply it to my organization. And in my organization, I mean, no organization really should pay vary between genders, but in mine, I could see how there could be other reasons for that. Location in my situation would be an extremely good reason, as general managers up in our town, a more saturated market with tons more volume, could be expected to go ahead and make more money than managers in a different setting like Allegan or Muskegon, where it's kind of a less volume store. And then what also is important in my organization is that there are a lot of like supplemental pay, so making sure that there's no difference in the opportunities for difference in bonus pay or extra pay, so that way everyone has the same opportunities to make the same types of extra compensation. And that is going to be my presentation.